thank you so much for joining us today. I see that many of you are already online, so let's just go ahead and get started with our introductions. I am Dr. Melissa Stein, a Senior Project Associate with Policy Research Associates. And today's webinar is on responding to serious behavioral health symptoms in the courtroom, the role of each court partner. And we're really honored today to be joined by Judge Marcia Hirsch and Jennifer Johnson, and I will introduce them shortly. So before I get started, I will just cover a few introductory items. I've already introduced myself. You will see an icon at the bottom of your screen where you are welcome to also introduce yourself in the chat, who you are, what your name is, your role, what organization you're joining from, and we will appreciate hearing from each of you. Okay, I do see notes that there is an echo. And so do make sure that on your side, you don't have two devices that have the webinar pulled up. Okay, thank you for the feedback. Okay, so we'll continue. I would like to just briefly share that the views, opinions, and content expressed in this presentation and discussion do not necessarily reflect the views, opinions, or policies of the U.S. Department of Health and Human Services. Next slide, please. We do have a Q&A pod at the bottom of the screen, so you can click the More icon and click the Q&A icon, and there feel free to insert questions throughout the presentations, and we will address as many questions as the time permits at the end of the presentation. And when there's polling, we would love to have you participate in our polls. You should have just seen one pop up on your screen. Please just select and submit your responses. We are recording this webinar. Anyone who registered for this webinar will receive a notification when it is posted to SAMHSA's YouTube channel. And we will also share the slides from this webinar to everyone who has registered in the coming weeks. And then at the end of the webinar, we will have a certificate of attendance available for download. And this is for your personal portfolio. We are not able to issue CEU credits. We do have ASL interpretation for our meeting today. We are thrilled to be joined by ASL interpreters Dave Grotzer and Paige Bixby. And we also do have live captioning available. Click the live transcript CC icon, and then you can select your options from there. Okay, now I'd like to introduce you to our presenters today. Dr. Marcia, I'm sorry, the Honorable, I was going to give her another degree. So the Honorable Marcia Hirsch was the presiding judge of the Queens Drug Treatment Court, the DWI Treatment Court, the Mental Health Court, the Veterans Court, the Gun Diversion Part, and the Drug Diversion Court in Queens, New York. And she was appointed to the New York Court of Claims in March 2005 and was assigned to Queens Supreme Court criminal term. She presided over hearings and trials before she was assigned to the therapeutic courts in October 2005, where she remained until her retirement in December 2024. Judge Hirsch has lectured extensively on therapeutic justice, treatment courts, trauma-informed courts, and procedural justice. And she has provided and continues today to provide technical assistance to treatment courts, law enforcement, behavioral health professionals working with justice populations, and more. And she is a board member and the immediate past president of the New York Association of Treatment Court Professionals. And Judge Hirsch is a graduate of Union College and Syracuse University College of Law. She served for 9 years on the Rockville Center School Board and was a member of her community's Drug and Alcohol Task Force. And prior to taking the bench, Judge Hirsch was a general counsel and deputy commissioner at the New York State Division of Housing and Community Renewal. Jennifer Johnson is the founder and principal of J.K. Johnson Advisors and provides education, consulting, and technical assistance at the intersection of mental health and law. Ms. Johnson is a 20-year veteran of the San Francisco Public Defender's Office, where she was one of the founders of San Francisco's Behavioral Health Court. In addition to her work in the courtroom, Ms. Johnson has helped shape mental health and criminal justice policy at the local, state, and national levels. She was a co-founder of the San Francisco Police Department's Crisis Intervention Team Training in 2011, and she is a senior consultant with SAMHSA's Game Center, and she is a member of the Criminal Justice Advisory Panel for ARC's National Center on Criminal Justice and Disability. Ms. Johnson recently authored a chapter on mental health courts in the American Bar Association publication, Representing People with Mental Disabilities, a Criminal Defense Lawyer's Best Practice Manual. Other published articles include Burnout and Compassion Fatigue, What Lawyers Need to Know, and Justice That Heals, Promoting Behavioral Health, Safeguarding the Public, and Ending Over-Reliance on Jails. So now you know who will be speaking and presenting to you today. So let's just take a look at the poll results and see who is joining us for the webinar. So it looks like about 53% of you are joining from an urban location, followed by about 26% from suburban, and 21% of you joining from rural locations. And we do have about 3%, about 13 folks acknowledging that they are living on tribal lands or coming from tribal lands such as a reservation, pueblo, or Alaskan Native village. And then in terms of organization and role, let's take a look. It looks like the largest percentage, not surprisingly, is the judiciary, about 25% of you coming from the judiciary. That is closely followed by about 20% of you from community-based provider organizations, and then 19% of you representing government and policy. I also see a very good showing from corrections, probation, and parole, as well as folks coming in from public health and law enforcement. It looks like the folks who might be on a treatment court team may be attending this webinar. So that's really good to see. And without further ado, I'm going to turn it over to Judge Hirsch to start our presentations. Judge Hirsch.
Thank you. Thank you, Melissa. I also want to thank SAMHSA's Gain Center and Policy Research Associates for developing this program. It is my pleasure to present today with my friend Jennifer Johnson. We have presented many trainings together, so please understand that we may jump in, interrupt each other, and discuss some points together that we want to emphasize. So, our learning objectives today. We're going to be discussing all of the complexities of managing agitation and psychiatric symptoms in the courtroom and during court procedures. You will definitely walk away with at least 3 new strategies for addressing psychotic symptoms displayed in court, and probably a lot more helpful tips as well. You'll also distinguish how responses to psychiatric symptoms can differ based on the type of hearing, the type of court, the court partner's role, and the given temperament and behavior of the participants in our courts on any given day. That can change from day to day, from minute to minute. So I think another important point to emphasize is that we all have to be flexible and willing to pivot. I really like to start with this important reminder that individuals experiencing mental illness are people first. Individuals are not their diagnosis. It really troubles me when I hear a colleague say, oh, that person is a bipolar or a schizophrenic, or defining them by their diagnosis. Please, please remember that they are people first. So, we are now going to be concentrating on the person centered response to disruption in our courtrooms. Jennifer is going to go through all of these roles a bit later in her presentation, but we believe it's really important for you to understand what everyone's role is and to identify the different roles and the different strategies that each person can employ to make the courtroom and the legal process uh, easier and more compassionate for the person appearing in our courts. We also emphasize balancing fairness, balancing flexibility, and we also want to promote everyone's safety. Everyone who comes into our courtroom and our courthouse should feel safe. So, another thing that Jennifer and I speak about regularly is trauma. So, you are going to hear a bit about trauma today. I like to consider trauma to be the missing piece when we're dealing in our behavioral courts. So, let's start with the definition of what is trauma. The experience, well, first of all, the experience of trauma among people with substance use and mental illness, especially those involved in the justice system, is so high as to be considered an almost universal experience. The definition here is individual trauma results from, I call this the 3E slide, from an event, series of events, or a set of circumstances, first E, that is experienced, second E, by an individual as physically or emotionally harmful or threatening, and that has lasting adverse, third E, effects on the individual's functioning and physical, social, emotional, or spiritual well being. So keep this definition in mind when we speak about trauma as we go through this presentation, because we're going to assume that all of the people who are coming into your court have experienced some form of trauma at some point in their lives, and it may be in the past or it may be ongoing. It may be a situation that they're living in now, such as for anyone living in a situation with domestic violence. So just please keep that in mind as well. I just told you about the 3 E's. Now we're going to talk about the 4 R's. SAMHSA's trauma-informed approach. These are the basics that we need to understand as we go through our program today. We realize the prevalence of trauma and why the trauma-informed approach is important. We recognize that trauma affects everyone. And it not only affects the people in front of us, but it also affects our colleagues, our program, our other team members. 3, we have to be prepared to respond effectively and with compassion. And we want to resist re-traumatization. We don't want anyone to leave our presence on any given day feeling worse than they did when they walked in the room. We want to uplift them. We want them to feel better. So, what are some of the trauma-informed judicial practices that we should employ in our courtrooms? The first one is the most important. All of our judicial interactions have to begin with dignity and respect. We want to communicate effectively with our participant, with their attorneys, and with our audience. We want to express concern, give positive feedback. We don't want to use negative or punitive language. We also, and I know we have a lot of judges here today, but it's very difficult for judges not to be judgmental. And sometimes we don't want to appear judgmental. We want to be supportive. The courtroom environment, as we know, can be intimidating. So we do not want to re-traumatize any of our participants. The entire workforce should be trauma informed. I know Jennifer's also going to talk about training in her presentation a little bit further along. Ongoing training on trauma and peer support is essential. This is really important. I know I've done this work for just about 20 years now, and things change. We've learned to do things better. We learn new techniques. We learn new strategies. We learn new things about medicine. So it's really, really important to stay on top of changes and improvements and new strategies and techniques that we can use as we do our daily roles, regardless of our position within the court or medical field. Human resource systems also should be incorporating these trauma-informed principles. We have to also be sure to support our staff with trauma histories and those who are experiencing secondary stress or vicarious trauma. We know it's very difficult doing this work on a daily basis. And some of us and some of our colleagues may be experiencing some burnout and some trauma, and we are going to be talking about that toward the end of this presentation today. So I'm going to turn this over to Jen, but I just want you to set the scene for a minute for our participants, and to just imagine a person with mental illness negotiating this new building, this courtroom, while they're possibly hearing voices or being so depressed that it was hard for them to get out of bed and even come to court, or being so anxious that they couldn't stop shaking. Our courtroom environments are scary. They're confusing. There's confusing signage, loud noises, security, large crowds of people. So just keep that in mind. I'm going to turn this over to Jenny to talk about listening to mental illness and what that involves.
Thank you, Judge. The word listening here is really important. I think because it's very broad. When I taught law students, I taught at Berkeley for 10 years. I've also taught a lot of lawyers about what to do in the face of somebody who is experiencing a psychotic episode or trauma or something that we don't understand. And listening involves more than our ears. It really involves all of our senses. And I think that that's really important. Oopsie. I forgot about the little delay there. Sorry about that. So listening to mental illness. Now, I learned this the hard way by making mistakes, by saying the wrong thing, by not learning to drop my own agenda in the face of a person who was experiencing a behavioral health crisis. And I got a good lesson from a colleague, my guru, Dr. George Woods, who I worked with. He's a neuropsychiatrist. And he just said, Jenny, stop talking. I was like, oh, I was a little hurt. But once I did that, I started to engage my senses. And listening involves, I think, all of our senses. What is in front of us? And if it's something that we don't understand, what do we do? How do we navigate somebody who's living in a different reality than we are, and without having that interaction get worse, go south, or somehow escalate? And what we don't want to do is really engage or deny people's delusions. Instead, what we want to do is offer support without really clinicians can definitely have different ways of doing this. And I'm saying this as a lawyer in a courtroom. The best way for me to control those situations is to say something like, that must be frightening. Are you okay? How can we make you feel safe? What happened to you? Instead of, no, the FBI is not following you. No, these sort of common things that can really change the dynamic instead of calming it down. So dropping our agenda, what we think we might be doing in court one day, their dynamic places may be something very different, as it turns out, when somebody with a crisis is in court. So behaviors are symptoms. And I like to think of this as like the iceberg. What we see is the very tip of the iceberg. We do not know everything that has led up to a person coming into court and having a behavioral crisis. It may be, we may never know. That's the truth. And I think we have to assume that there's a lot going on. But mental health criteria, we don't actually often translate into like everyday behaviors. We say dissociation, we say mania, we say a lot of things. But what do those things mean? And what do those behaviors mean? The behaviors might have a different meaning in the mental health context. Okay. So, for example, we say they have symptoms of depression and anxiety. Well, irritability is a symptom of many mental health disorders. You may have someone experiencing irritability and they're not actually not irritable. They're depressed. They have something else going on. Daydreaming, someone's not paying attention, losing focus. That might be dissociation. It could be an epileptic seizure. It could be so many things that we don't know. And so we have to come in with a neutral approach. Cooperation, this is one that happens a lot. And if in a busy, dynamic, moving courtroom, cooperation from someone can seem really convenient. Like, okay, yes, they're doing exactly what I asked. They're not, objecting to what I say. However, that can really be a sign of cognitive impairment. It may not be cooperation that is what we think of as cooperation. Some behaviors may have more than one explanation. Somebody could be detoxing from drugs. When we meet someone who's in a mental health crisis, I do a lot of training with police. We have no idea what's going on. It may take a long time for a doctor to figure out what's going on. So we have to be humble and we have to be respectful of that person and know that, God, we don't know everything. The other thing is that mental health symptoms often overlap. We talk about co-occurring disorders. There are so many ways, so many variations, and so many complicated interactions that we, standing in court, are not going to be able to figure out in the moment. So what do we do? Well, we can't do anything unless we have trust with the person that's in crisis. And I'm a defense attorney as by training. I've also worked for 4 years in the sheriff's office. So I have a broad sort of base of experience. But if I'm talking as a defense attorney, I want you to ignore that and think of your own self in your position in the courtroom. It's just a default that I have, I guess. But for me, trust with my client was absolutely essential. Nothing good was going to happen if that person didn't trust me or trust the process, trust what I was doing. And the hard part is that mistrust is the through line of so much of what people in court with who are having a mental health crisis have experienced. They have been they have not been served well by our systems and have a really good reason to not trust our systems. So there's that at the very heart of this. But the other thing is that these mental health issues may complicate it. Someone may have reality confusion. They can't trust their own brain. They might have paranoia, which is a really common symptom of thought and mood disorders, people with schizophrenia, people with bipolar disorder with psychotic features. People with intellectual disabilities, they just may not understand. And what the judge said, I think, is so important about trauma. We have sort of assumed, we just sort of assume that we need to assume that trauma is part of everybody's experience that comes before us. That can be an individual trauma, it can be complex trauma, and that can make people self-protective, it can make them mistrusting, and it can really interact with other mental health disorders and addiction issues that make this a very confusing picture. When we're working with people with mental health issues, I think that what they don't say is very important. So beginning sort of with nonverbal clues. What's the emotional presentation? Is it consistent with the circumstances? What are they wearing? Maybe they're wearing jail orange, which is, that's one thing, but you may have clients who are out of custody, or you may have people that you're working with in a civil context. There are all sorts of situations, but is their clothing consistent with the environmental conditions? What about motor movements? Gait? Is there trembling, tics, focus, hypervigilance, grooming? How do they present? And oddly, like scars, tattoos, what I'm asking you to do is open your eyes and open your senses. I am not asking anyone who's not a clinician to come up with a diagnosis, but what I'm telling you is these things are clues to understanding who is in front of you, and they are clues to helping you behave in a way that helps the situation rather than aggravate it, escalate it, and re-traumatize someone who's in front of you. It's information. I like to say when I'm in court or when I'm meeting with someone, I'm the court reporter. I'm observing, I'm taking everything down, and then I'm the conduit to a professional who could help me understand it. So opening our eyes, listening with all of our senses is really important. Now, we can also find super interesting information in the content of someone's language. What are they saying if we're listening? A movie star is in love with me. That's called neurotomanic delusion. Grandiosity, I am king. That's a grandiose delusion. You might hear someone expressing suicidal thoughts. What we see so often is a lack of mental illness. I am not sick. I do not have anything wrong with me. I mentioned this one, the FBI is after me. They put transistors in my teeth or other body parts. That is so very common in my experience. It's helpful, again, not to diagnose someone, but just to understand and help you put it into context. Ideas of reference, I think, are interesting. Everyone is talking about me. All of these things that are happening fit into a pattern that becomes a delusion or that fits into a larger delusion. So what is inside the language holds clues. The other thing that holds clues for us is the structure of the language. How does the language sound? Not the content, but is it loud? Is it hard to interrupt? Is it brief with nothing? There's nothing going on. Is it word salad, nonsensical, gibberish? Does the person lose their goal? They start on one thing and end up way somewhere else. Is somebody perseverating? Are they hung up on something that they cannot get beyond? And these are, again, if we're just listening, so you're not going to maybe know that the word is tangential or perseveration. It doesn't matter. What we're doing as observers in the courtroom is taking notes, taking it down so that we can better understand. And with that, I'm going to pass this back to Judge Hirsch, and I will come back in a little bit.
Thank you. Yeah, mental illness, as you've probably figured out by now, is very, very complex. With respect to the serious mental illnesses, they're all interrelated. That's why we included this slide. When we talk about people with affective disorders, these are the mood disorders that are characterized by significant, persistent disturbances in their emotions, most commonly depression or bipolar disorder. That's what we segue into next here, bipolar disorder, where we have people cycle between high energy mania and low energy depression. Then I'm sure you've heard about people diagnosed with schizoaffective disorder. That too being another chronic mental health condition characterized again by a combination of schizophrenia symptoms such as hallucinations, delusions, disorganized speech, and the mood disorder symptoms that we just spoke about, being mania or depression. Lastly, schizophrenia. This can all be part of a continuum. Schizophrenia affects how people see things, how they feel, how they behave. Hallucinations involve seeing things or hearing voices that aren't observed by others. Delusions involve firm beliefs about things that are not true. Jenny just gave you some examples about that. The person being king, or with the FBI putting microphones in their teeth. People also seem to lose track of reality, which can make daily living really, really hard. So, all serious mental illnesses are interrelated. They are all complex. They all have subtypes. Some are genetically related. A person with schizophrenia is more likely to have had a relative with bipolar disorder as they are to have a relative with schizophrenia. So sometimes you'll hear it said, oh, mental illness runs in that family. Yeah, sometimes things are genetically related. But the expression of the mental illness is not one thing but many. Remember again that they're people first, that there is a mix of genes, and that there are also environmental influences, and we have to meet the individuals where they are. Jenny spoke about co-occurring disorders, and I know that this probably is not a surprise to any of you who've been practicing in this field. Co-occurring disorders are the rule rather than the exception. You can see that from this slide here, which analyzes the anxiety disorders, the PTSD, the alcohol abuse, drug abuse. And you can see that there is definitely a lot of overlap. And sometimes you hear it said, well, this person has been self-medicating with drugs or with alcohol for many years, possibly even before their diagnosis with mental illness may have been made. So we may have to be sure that a good treatment plan may contain some treatment, substance abuse treatment for alcohol misuse or drug dependence. And again, cautioning here, we judges and lawyers, we don't make those diagnoses. You have to let the professionals make the diagnoses and make the treatment plan. So you'll often hear it said, stay in your own lane. And yeah, that's really, really important, especially when we're working with the complex issues that our people often present with. I really like this slide because it does show how everything is interrelated, that it's not a comorbidity, it's polymorbidity. So you do have people who suffer with post-traumatic stress disorder. Sometimes those might be our veterans or anyone who's suffered significant trauma or accidents in their life. We talked about substance use disorders, a TBI, traumatic brain injury. That can be from accidents, from head injuries, from serious assaults. Our veterans, many of our veterans who are in combat suffer from traumatic brain injuries. And then we get into the mental health diagnoses, the bipolar disorder, depression, insomnia. Many of our people suffer from insomnia. People who come into court late say, you know, I took my medication and I just overslept. I'm sorry, I just overslept. I was up half the night and then finally I fell asleep and I'm late today. So they do struggle with insomnia. And on the flip side, sometimes they're over medicated and they're sleeping more than expected or than usual. People who deal with pain, all kinds of pain, physical pain, emotional pain, and some people may be prescribed medication for serious pain, especially the chronic pain, back pain, neck pain, knee pain, all of those things. And anxiety. Most of our people who do come into our courtrooms do suffer from some type of anxiety. So all of these things can be at play in any one given person on any given day, or so it's a Chinese menu approach. They may have several of them, but we have to be aware of that and be sensitive to what they are struggling with. Also, just another cautionary word on when some of our people are taking illegal drugs and they are also on psychotropic medications, please be aware that recreational substances can interfere with the prescribed medication and can really make them feel worse. And I know we used to see that. I know, especially with marijuana use, and especially in our jurisdictions where marijuana use is legal, recreational use is legal, or some people are receiving medical marijuana. Sometimes it does interfere with psychotropic medications. So that's, again, why you really need to get the whole picture to know what your people are being prescribed and to know what their professional, what their psychiatrist is prescribing and what they're taking and how that may interact with the other drugs that they're taking. Jenny, did you want to say something about that as well?
No, sorry.
Okay.
I might have looked like I wanted to. I'm sorry.
Oh, okay. Okay.
I guess
So
it goes to the point that I made earlier, which is we just don't know what's going on. There's so many possibilities that we have to come in with humility.
absolutely. And sometimes there's also such a thing as substance-induced psychosis. Sometimes when the drug use stops, the psychotic symptoms stop as well. And we have to be aware of that. So that's, again, why really good communication with the psychiatrist is important. I've had people be on psychiatric meds and while they were abusing illegal substances, their mental illness was really exacerbated. Once the illegal drug use stopped, the psychiatric symptoms stopped. So I've had psychiatrists then stop prescribing psychotropic medication because the person didn't need it any longer. So that's why you really need that ongoing dialogue with the psychiatrist. And things change from month to month. So you really want the most up-to-date medical information that you can get so that you can help your participant. Trauma-informed environment. This is one of our favorite things that we talk about. Is your courtroom and the court-related environment sensitive to trauma? I encourage people to walk into their courthouses like a visitor would and to see what they see, to go through the magnetometers, to look at the signs in the hallway, to look at the signs on your courtroom door. Are you the land of no? Do you have that big sign there with the red circle with the no eating in court, no reading newspapers, no tank tops, no talking, no food? Do you have all those signs in your courtroom? Are you the land of no? You may want to revisit some of that. I know you have to keep your environment safe for everyone, but being the land of no can be really intimidating, especially for a person with mental illness. One of my key takeaways here is how calendar management is crucial. And judges, that's really under your purview. That's your domain. I know sometimes our clerks think they run our calendars, but we're allowed to say which cases we want to advance, which cases we may want to deal with first, and how we're going to handle our adjournment schedule. Some of our people, as I mentioned before, may be really super anxious. They can't wait to get out of your courtroom. They want their case called. They want to deal with what you have to say, and then they want to move on with their lives. For other people, they may love being in your court. They may love coming to court. They develop relationships with your staff, with their case manager, with the court officer or the bailiff. Some of those people really like to come to court. With the incarcerated, I also want you to be especially aware that in a lot of jurisdictions, when the incarcerated come to court, they have to wake up really super early in the morning, sometimes like 5:30. Sometimes they have to get on the bus at 6. Sometimes they're given their medication at 5:30 in the morning. So what's going to happen with that individual if you don't see their case until early afternoon? Their medication may be wearing off. You have to be aware of that. So, with the incarcerated, you may want to handle some of those cases earlier uh, in your calendar or earlier in the day. Having a really well-trained staff is super, super important here. I've had my court officer come in to see me before I even took the bench on given days to say, I think Mr. So-and-so is really, really over medicated today. He's nodding off in the back. He really has a very, very hard time staying awake. Maybe you should call his case first, or maybe even adjourn it to another day, but he doesn't seem well today. That's why training your staff really pays tremendous benefits for you. Same thing with your clerks. Also, similarly, if someone's actively psychotic, if someone's hearing voices talking to themselves, you want to know that before you take the bench. I know Jenny will talk about that in a little while about how it's really especially important for defense attorneys and for peer advocates to enlist them sometimes when we have people who are really experiencing serious symptoms in our courtroom. Then, too, we may have people under the influence of substances, people who just seem really high and out of it. So we have to know that as well. There, you might want to give a short adjournment. You may want to say to the person, "How are you feeling today? You seem a little bit different than when you were here the last time. How do you feel? Is there anything that you need that we can help you with?" Maybe have you been going to your treatment program? If they're in treatment, how are you doing there? And then maybe you might want to give a short adjournment to see and follow up and check in with them to see how they're doing. So flexibility is really, really super important. Another thing that we want to be sure that we do is to provide written instructions for our participants with dates, locations, and appointments that are involved. Written instructions that have to be simple, easily worded, step by step, with dates, with times, and then ask if someone can assist or if someone in your staff perhaps may help the participant put their calendar reminders on their cell phone if they're not able to enter that information. Use forms that are simple for the participant to understand. No big words here. Your forms should really be written, I believe they always say, like, for people with the 5th or 6th grade education. Be conscious of language proficiency. Do we have forms that are bilingual or in other languages? When I sat in Queens County, we were the melting pot. We had lots of different languages spoken there. So we had to be sure that we had court interpreters there who could explain things and could assist with when we wanted to provide simple instruction or if we needed forms in different languages. Be conscious of those things. Similarly, for people with developmental disabilities, we there too may have to break things down into simple steps so that they can follow along. And you may want them, after you've given those directions or instructions, you may want them to repeat them to you and to find out how they understood what you said. Again, basic literacy is so, so important here. Remember, a lot of our people in our courts, these aren't the people who were on the honor roll and the high honor roll when they were in school. A lot of them did struggle with literacy and have problems there, or may be dyslexic, have learning disabilities. We need to be aware of that so that we can make things easy to understand and help them comply with what we want them to do. Here too, we want to have them focus on what the goal is. We want them to live their best life. That's our bottom line here. So if that involves going to therapy, going to treatment, going to a trauma support group, going to substance abuse counseling, going to a neighborhood clubhouse, going to programs at their local library, whatever it is, what's the goal and what do we want to encourage them to do? Explain that. Explain what you want them to do and why you want them to do it. Do you ever remember that teacher in school who just said, "You do it because I said so"? No, that's not the right answer. We don't want people to do things just because we say so. We want them to understand, and we want to be honest with what we expect them to do and what the consequences are, and both what the rewards can be for them if they follow the program and their treatment plan, and if they take advantage of the supports and the recovery capital and all of the things that we in our courts and our treatment court settings can help provide. When we speak with our individuals, Jenny talked about listening, and that's super, super important. But it's also important that we speak slowly, that we make eye contact, that we use their name, call them by name, that we exercise patience, give positive feedback, repeat the important things. I was a big note taker, and I think it's super, super important to keep notes from court appearance to court appearance so that I could follow up on one thing that or another thing from a prior court appearance. So say that you had a participant who indicated that they were taking an art therapy class and they were really enjoying it. You can follow up on that. Say, how's that art therapy class going? Maybe when you come in next time, maybe you'd like to bring one of your pieces of art with you. Maybe we'd like to see that. And I've seen some amazing works of art in my courtroom. And I've also seen pictures from a 3 or 4-year-old's coloring book. What are they working on? What are they bringing in? And you know what? We compliment them on whatever they bring in, and we encourage them to continue doing that. I had a woman in my mental health court who loved to go to the public library, and she loved to read self-help books. She was in a residential program. She convinced the program that she would like to bring some of her colleagues to the library. And they may have had book discussions, and she could always tell me what book she was reading and all of these self-help things. But that was something common that we could talk about from court appearance to court appearance. And it was important. It showed that I cared about her as a person, and I wanted to know what she was doing with her free time. So all of those things really show the compassion that we want to show, and the fact that we really are looking at our participants, again, as people first and not their diagnosis. It's important to respond and not to react to criticism. Sometimes people will tell you, I don't want to be here anymore. I don't like going to therapy. I don't like doing this. And sometimes they may really have strong feelings about that. If they do, you really cannot react angrily. Ask them to explain it. Use your motivational interviewing skills. And there are some terrific materials out there on motivational interviewing and motivational interviewing for people with mental illness. So please try to search out for some of those trainings and some of those publications, and they'll give you some new questions and things to ask of your participants. Allow the person to speak. Allow them to say, maybe they say, I'm on this new medication and I hate it. Say, well, how does it make you feel? What don't you like about it? Allow them to speak. But then you can also say, but you know what? I really want you to talk about that with your psychiatrist at your next appointment. And in the meantime, I know that you're uncomfortable, but please don't stop taking the medication. Continue to take the medication until your doctor tells you otherwise. So again, you're forming that alliance with the person, but you're also wanting them to form that alliance with their mental health professional. Give choices where possible. We talked before about people sometimes with insomnia who sleep late in the morning. So you may want to ask them, would it be better for you to do treatment in the afternoon or late afternoon or early evening? Give choices. Also give positive feedback. Hey, I saw you made all of your appointments between the last court date and now. Wow, that's really terrific. And then ask them, what did they really enjoy about a certain group that they were doing or a certain therapy maybe that they were working with? Ask and give positive feedback. No finger wagging or pointing. Again, remain calm. Also, I've always found that if someone is really agitated and very, very upset, keep your voice and your tone even. If you speak more quietly, they will speak quietly also. So, really lower your voice, keep your tone even. If necessary, you know what? You can call a second call. You can say, Mr. So and so, you seem really agitated today. I'd like to give you a few minutes to go out and speak with your attorney or a peer or a family member who's here with you. I'm going to call your case back in a few minutes so that we can have a more productive discussion and we can move forward. Again, use that individual's name often or more often than usual. It really, really does make a difference. With respect to what you're asking them to do, paraphrase, summarize, ask them to summarize what the instructions that you've given them. Please don't use jargon. Don't use legal terminology, Latin phrases, numerical sections of the statutes. We've all heard those things done in our courtrooms. The people who are appearing in front of us, they won't understand those things. And it won't help them. It may just confuse them. It may produce more anxiety. And avoid any unnecessary intrusion. I know we were speaking about trauma before, and here I want to caution you, while we want to be trauma sensitive, you never, ever, ever want to ask the person to talk about their particular trauma with you in court. Okay? That's not your job. You can acknowledge that they've experienced trauma, but you're not the therapist and you don't want them to describe or talk about those traumatic events in court. There you would be doing far more harm than good. And please remember that words can hurt. I like this courtroom communication slide. It again just gives you some things to say that are trauma-informed, the trauma-informed alternative. Like we would never say your drug screen is dirty. You'd say your drug screen shows the presence of drugs. Did you take your meds today? No, that's not what you'd be asking. You would say, are the meds your doctor prescribed working well for you? You didn't follow the contract. You're going to jail. We're done with you. There's nothing more we can do. No, absolutely not. That is not a trauma-informed way. And even when I felt particularly frustrated and we'd been working with people for a long time and it seemed like nothing was working, that was the time that you'd say, hey, we notice you're struggling. What can we do to help you? What do you need? And you know what? They really knew. Sometimes they'd say, my counselor left the program and I have a new counselor and we're just not hitting it off. Or I really need more individual therapy. Or this group is not helping me. I really need another group. What do they need? Similarly, I'm sending you for a mental health evaluation. Then they would assume you're saying, oh, I must be crazy. There's something wrong. The better way to say that is I'd like to refer you to a doctor who can help us better understand you and support you. And remember, everyone else in the courtroom is observing also. So this is your opportunity to talk and to teach everyone by engaging and setting examples. You're communicating the important principles, and you're also explaining differences for different outcomes from different litigants. Jenny.
Thank you. So Judge Hirsch mentioned that who's in the courtroom, and she had the diagram that had a few. And I put this up here because it's a public place. We walk in, the judge takes the bench, the bailiff is there, the court reporter is there, but there are also survivors of crime. There are witnesses. There may be police officers, experts. There might be family members, children. There might be members of the press. There will be mental health providers. And obviously, there are members of the public who are observing. And there are obviously a ton of lawyers that are in the courtroom, unfortunately. But the courtroom is a very complex place, and we have to understand that that's who the audience is. And when something goes wrong, and when someone is having a mental health disruption, there's a lot going on. And what we want to do is to manage it. There's no easy way to say this is how you handle a person who's disruptive. It's about flexibility, it's about humility, and it's about knowing as much as we can and acknowledging there's a lot of people in this room who are here for different reasons and who have different roles and different goals. So from the point of view, the reason that I focus here on the defense lawyer is that the defense lawyer is often the person who is representing the person who's disruptive. That it's not to say that there aren't other people in the courtroom, witnesses and other things, but most frequently it's going to be the person who's in court for their matter and is not doing well. So the defense attorney has access to the mental health history. They may know the person. They have information that can be shared in certain situations. They're perhaps familiar with the person's symptom presentation. I had a client in the mental health court, and we always knew when he was off of his medication and using crack because he wore gloves to court. We always knew he was wearing gloves. Okay, we know this might be an issue. I might tell the judge, I might tell the bailiff. He was someone who could get quite violent. And it was my indication to say something like, hey, let's be prepared. Not to say, oh, he's using drugs, judge, put him in jail. That's not the reason. It was just information to keep the courtroom safe and to minimize whatever might happen. I really think that in a lot of cases, that's our goal. It's making the courtroom safe and making it efficient and reaching whatever goal it is. That goal may change through the course of the day, but we have to steward the person through that experience in the best way that we can. So as I said, the public defender, the defense attorney, or the person representing the person with the issue can collaborate with the judge, the bailiff, the prosecutor, and work together to minimize and lessen the trauma for the person who's going through it. We have to also be aware of, like I said, of who's in the audience, of who might be affected, and just again, listening in the broad sense to read the room, who is here, and what's my best pathway through this. The other thing I think is really important and something that I learned to do and that everyone can do is not only be a court reporter and take down the information that you're seeing, but also become the narrator. When you walk into a courtroom, we are speaking a totally different language. It's numbers, it's Latin words, it's all sorts of things. It happens quickly. I can remember sometimes not even being able to catch up. Well, imagine the person who's in a mental health crisis trying to catch up to that. It's impossible. To the extent that we can, telling someone, this is what's going to happen next, this is what's going to happen next, is incredibly effective. It reduces anxiety in the person. It really helps things run smoothly. I used to go into the holding tank. I would say, you're going to come out. This is who's going to be in the courtroom. We're going to stand there. This is what I'm going to say. This is what the judge is going to say. And I would keep going while it was happening. And it went a very long way to minimize that person's anxiety and the potential for escalation. It's really, as much as it is, what do we do when someone's disruptive? How do we keep someone from being disruptive? And we have a lot of control when it comes to that. So being a narrator is important. I think the judge said something that I think is important to think about. And for a lot of people, we talk about this black robe effect which I feel like is, I don't like the way sometimes people talk about it. It's like the judge has the power to put you in jail. You should be afraid. I don't view it that way. I view the black robe effect as the judge having an opportunity to give someone an audience, to let them have agency, autonomy, narrative autonomy, to be able to tell why this happened. I think it's an opportunity for dignity and respect versus a hammer. So that's my soapbox. I'm going to get off my soapbox, but a courtroom can be a very therapeutic place if we operate under the right conditions and if we know how to do that. It can be healing versus a place of fear and harm. Again, like the disruptive person might be a witness. It might not be the defendant. Again, from the people who work in a collaborative court, a lot of this is a treatment court. This is not a surprise. And the district attorney's role is going to change depending on what type of court it is. And it's different in a family court, a juvenile court, criminal court, civil court. So the prosecutor understanding the job of the other people in the courtroom, the role that they're playing, and how they can contribute to de-escalation is really, really important. I cannot say enough how important training is. We are in courtrooms, there are personnel changes all the time in civil court and criminal court. You get a new set of judges every January. You get a new public defender. One untrained person can unravel the entire process. If you have one person who is not trauma informed in a courtroom, that can spell disaster. And unfortunately, mental health and trauma training have never been a top priority in what we do. Judge, we present all the time. For us, we think it's a priority. We think everybody knows this. But you walk into any courtroom on the first floor of the Hall of Justice in San Francisco that's not a treatment court, people don't know this stuff. It's not getting through. It is immensely important both to protect us, to make the job easier, to make things easier for us. So training really is important. The science of mental health is constantly changing. And in order to be very good advocates for all of us to find the right solution, we have to know what's out there, what community resources are available, how do we access them, and where is the best place what are the best resources for this person that is in front of me? So this is actually an entire course that I have taught on burnout and compassion fatigue. I say it here to say that if we are working in a court system, that we are able to say and acknowledge this is a hard job. We shouldn't be afraid to say that. We can't walk in with bravado. This is a hard job, and we should honor ourselves and take care of ourselves. So it could be the conditions of the job, which are stressful, high stakes, high expectations. It's also the content of the job. Listening to stories of tragedy, violence, without the resources that we need can take an immense toll. And we can end up with burnout and compassion fatigue, which are two different things, but they can exist together. And if and when they do, sometimes I put this slide in red because I really want to emphasize it. If we are not mindful, we ourselves will have relationship problems. We will self-medicate. We will perform poorly at work. We will remain in denial, and we will get physically sick. It is important that we take care of ourselves because we don't want to be another reactive player in a courtroom that is tense and has dynamics that we can't predict. We don't want to contribute to the problem. We want to minimize it. So, taking care of ourselves, I've written on this a lot, and I think that when we are in this world, particularly in the criminal justice system, there's a lot, it's an adversarial system. It's built on argument, it's built on fighting, and that activates our nervous system. And we have to understand that we have to take care of our nervous system or we're not going to do well. So, this goes beyond treatment courts. I guess my dream is that all courts would be trauma informed one day. I think we're a long way from that, but we got to start somewhere. And we've learned so much in the last 20 years about how to do better in a way that translates to any courtroom, civil or criminal. We should always be person-centered and focused on dignity. We need a smooth, functional court process that can be healing. Do not forget, it can be healing if we are mindful. So these are sort of my dreams. How do we get everyone to care? How do we get everyone trained? And what's the minimum standard? Like, where should we be? And how do we get there? So those are sort of my call to action questions for this group. So I think that's my last slide. And I apologize, I went a tiny bit over, but okay, there's Melissa.
No worries. This was such important information that I definitely wanted to make sure you all could get through all of your slides. So we do have time, a little bit of time left now for Q&A. So we really welcome you to insert your questions in the Q&A pod, and that's where we'll be going to pull questions and have more of a discussion. So I really appreciate all the chats that have come through, and Jennifer and Marcia, if you haven't yet, take a moment to look through some of those chats. There are some really helpful comments and agreements there. And so in terms of the questions, let me just take a quick look. Okay. All right. So, one question is around a judge. If you have a judge that isn't responding well to a situation, the question is actually asking for steps for reporting a judge. And Judge Hirsch, correct me if I'm wrong, but my sense would be that would depend on the state. But
Yes.
what might be your recommendations for court partners, behavioral health folks, other folks in the courtroom that may witness a judge that might not handle the situation very well? From your perspective as a judge, what might be some helpful ways that they could respond to that situation?
I think the first thing that you have to figure out is the judge just having a bad day, or is this the way the judge is every single day? If this judge is like that every single day, perhaps that's not the best assignment for that judge. You may want to speak with an administrative judge in that building and describe what you've seen, what you've observed, because chances are you aren't the first person that's going to be telling the administrator that. There may be other people who've made similar complaints along the way, but it's really important that you stick to the facts, be very specific. If you have a copy of a transcript that you want to show to share the administrator, you want to be professional about it. You just don't want to be Debbie Downer or somebody who's whining because you don't like a result. You want to indicate that that the interactions really haven't been helpful, and that that there are better ways to do things. So,
And Jen, you have, been in the courtroom for many years. Anything you want to add to that?
No, I think Judge Hirsch got that.
Okay. All right. So, we did have someone comment accurately that, a lot of our thoughts tend to just naturally gravitate towards the treatment court setting, but, we also see these issues in just your traditional criminal court settings. And so, would there be any differences in what you are recommending or any other considerations that folks might want to think about in the more traditional criminal court setting? Let's start with Jen for this one.
No, this is a tough one. I think that over the years that I was in San Francisco, that the judges began to understand, and in the other courtrooms began to understand that when someone had mental illness in front of them and they didn't know what to do, they knew who to call. Usually it was me. I'd get called to a lot of courtrooms to figure out what to do. But I think having a network of information that judges can access to know how to manage a situation is really important. I have to say, we are a long way from having every courtroom be to be trauma informed and to be sensitive to this kind of stuff. The changes in our court system are so fast and so furious that it's hard to keep up. But that's why my call to action is, how do we get this information to all of the players in our systems? How do we make it urgent? And how do we make it so that people want to have this information? I don't have a real answer. I think knowing who your experts are in the building is very important. I would say that would be the first step. Judge, what do you think?
I know that through the Council of State Governments that they have the Judges and Psychiatrists Leadership Initiative, where they do trainings of court-wide systems for both civil court judges, criminal court judges, everyone on mental illness, on trauma-informed principles. And their goal is to train every judge in the country on this. And I know I've done a lot of training in our state and in other states on this, and it is a wonderful, wonderful resource to look into, especially for annual trainings and also for new judge trainings. I say start at the beginning. Start with that first judge assignment and begin there.
Another avenue toward this I was just thinking about, Judge, is there is in the legal system more of a focus on wellness. The American Bar Association has been focused on it. A lot of big law firms are focused on it. And understanding, what can happen to lawyers is that they can end up exhibiting the same symptoms as the disruptive people in court. That's really the truth. We can end up exhibiting trauma symptoms. So using the idea of wellness as a way to educate people could be another avenue into broadening the sort of base of who knows about this information. I don't know.
I agree. And I think we're seeing more of that now. I think people are more aware of it. And I know that there's a great need for it. And there are many, many training sessions on it. So it's just a question of finding them.
Yeah.
And I think that wellness piece also can apply to our law enforcement, our security officers. And, we've been having conversations at the Gain Center about how some of these different approaches to treatment can support wellness of our law enforcement side. So when we're thinking about law enforcement, bailiffs, those providing security in the courtroom, someone asked, how could we create buy-in from those folks to support more of this type of approach? So what would be your thoughts? Judge Hirsch, we'll start with you.
I think that it's really super important to, if you're having a training in your building, it's really great to invite everyone on your team. Speak to your captain or your law enforcement people. Open it up to them, your stakeholders. the more people around that table, the better. And I know that a lot of times we can't do lunch and learns because sometimes there are union rules against that. So you may want to do a breakfast and invite people to come before. Or you may want to take a day or part of a day when the calendars are light and just do additional training on a given topic, on say certain mental illness diagnoses or trauma again, and how to deal with someone who's experiencing trauma. And just training absolutely everyone. That's so important. The clerks, the bailiffs, the interpreters, the stenographers, all of those people need it as well. So we all can do a better job if we are all better trained.
I could not agree more, Judge. When I was in San Francisco, we started a thing called the Collaborative Court Speaker Series,
Yes.
and it was held in a state building that was neutral, not in anyone's office. Everyone was invited,
Yeah.
and everyone could get credit. It was post certified, it was MCLE, it was clinicians, and it was a safe, neutral space to teach people about things that they didn't necessarily know about or didn't know they needed to know, which it doesn't exist anymore, which I think is a shame, but I thought it was really good.
Yeah.
It did.
And Jen, you have a background, you did work in a sheriff's office once. Are there any messages or language that you would recommend using in sparking their interest in this type of training or approach?
Yes, I did some wellness stuff when I was at the sheriff's office because the sheriff knew that this is the work that I had done. And when I started reading about law enforcement, they have training, they do have resources. We had a behavioral health unit where they could access services. The most important thing is the statistic that when law enforcement retire, they live for 5 years. That was more important than any other piece of information I could convey. That was, and that doesn't need to be the case. It may be longer now, but that's sort of the number that people talk about in law enforcement. And when you talk about health consequences, I think that's really how you get to people. Like, why do you have an ulcer? Hey, why are you not sleeping? Why have you lost weight? These are ultimately that it takes such a toll on us that that's the end product, and people can relate to that. I also think that people can relate to the science of it, which is, if you're in a heightened state of alert and your nervous system is activated all the time and you never come back down, you begin to live in that state and you are reactive and you are not effective and you don't do your job as well. When you tell people you don't do your job as well and you might die early, they start to listen. I mean, I hate to be so like heavy-handed about it, but we work in a world that's hard to get through to people, and the culture isn't nurturing. The culture doesn't help us. It keeps us from taking care of ourselves. And there are reasons why that's true for lawyers, and there are reasons why that's true for law enforcement that are different, but equally, they create an equal Teflon, if you will.
Well, thank you for that. The last question I think I'd like to just bring up is from a family member. And this is someone who said, my loved one who lives with a serious mental illness has been treated terribly by judges, prosecutors, even public defenders. How can I share this information with the court systems in my state? Would you have any ideas or suggestions?
Maybe through NAMI. If they have a NAMI organization within their state, I think I would start there. And I mean, more of our states do have mental health courts. Maybe this person's particular locality does not. But, if they don't, you want to go to your legislature and say, hey, we need this. We need this. We need to be able to have access to to mental health courts and the kind of treatment and therapy and really good practices that can help my loved one navigate the system. So you got to be an advocate sometimes.
Yeah, I agree. There's some organizations in California that also
Mhm.
the families apart from NAMI.
Yeah.
Um, but I think connecting with other family members, there may be networks to get this information out to people and to the court systems. I think I agree, Judge. You just have to reach out. Don't assume that there's nothing out there. You
Right.
find some resources
And
that really
and
help.
also if there are trained peers and the peer support organizations, I know they too do a lot of advocacy in this area. So you may want to find out if there are any peer support specialists or advocacy organizations there, because they do a great job of going out to the legislature. And I think this isn't this Mental Health Awareness Month right now. I think I just saw something that I know that it's a good time to talk about these things, especially as state budgets are being crafted. Ooh,
Yes, the experts in the chat are confirming it is Mental Health Awareness Month. So thanks
okay.
so much, folks, for that. And that's the beauty of these webinars. We have folks with wide range of backgrounds and expertise joining. So thank you for sharing that. And yeah, this recording will be posted on SAMHSA's YouTube channel. We will share the slides with folks who have registered for this webinar. So feel free to get that URL, that link, once it's on the SAMHSA YouTube channel, and share that. This webinar itself could be a resource to share with partners in your community.
And also the Judge's Guide to Mental Illness in the Courtroom, Brianna posted the link to that in the chat as well. And for my judges, it's there. And for those of you who work with judges, print it out and provide a copy. There's a lot of helpful tools and just simple information, some of it that I covered today.
Yes, thank you. And I hope you both will take a look at the chat and see the feedback that's coming in from folks. And we really do appreciate so much both of you being with us today and sharing from your wealth of expertise and sharing this critical message that is resonating clearly with our audience and is greatly needed.
Mm-hmm.
So Brianna did just drop in the chat the link to the Judge's Guide to Mental Illness in the Courtroom again, if you haven't seen that yet. And we also have a certificate of webinar attendance that was just dropped in the chat as well by Sam Rogers. And so you can click on that and follow the instructions of your device to download it to your device. And you will need to personalize it with your name.
Mm-hmm.
Okay, next slide, please. And we do have a poll that just popped up. If you would like to provide additional feedback regarding what would be helpful, we would greatly appreciate that. We do take this into consideration when planning future work. And if you are not signed up for our listserv yet, here is a shortened URL, or you could also pull up a camera and pull up this QR code. It will take you directly to the webpage to sign up for the Gain Center's listserv, where you can find out about forthcoming webinars, as well as receive a quarterly newsletter where we like to feature programs across the country. It would also be a place where you could learn about other technical assistance and services being provided by the Gain Center. So please do sign up for that if you haven't already. And if you have any additional questions that were not answered, feel free to reach out to us here at the Gain Center. We do have funds to provide phone-based technical assistance. So if you do have questions about mental health court or behavioral health courts, treatment courts, and you would like additional assistance, feel free to reach out to us here at the Gain Center. Our website is there at the bottom of the screen, and our toll-free number is at the very bottom of the screen. So we welcome you to reach out to us. SAMHSA's contact information is also available here. Next slide, please. Okay, I think that was it. All right, we do have some forthcoming webinars, and once we're ready to announce those, we will share that information. So thank you so much to all of you for joining us this afternoon, and thank you again to Judge Hirsch, Ms. Johnson. We really appreciate you being with us today. Have a great afternoon, everyone.
Thank you.